Manu talks about 18 different types of cases that could come up before courts. What are those 18 different types of cases that could come up before court according to Manu? Payment of debts. Number 2, deposit and pledge. Number 3, sale without ownership. Number 4, concerns among partners. Number 5, resumption of gifts. Number 6, non-payment of wages to workers. Number 7, non-performance of agreements. Number 8, rescission of sale and purchase contracts. Number 9, disputes between the owner and servants. Number 10, disputes regarding boundaries of properties. Number 11, assault. Number 12, defamation. Number 13, theft. Number 14, robbery and violence. Number 15, adultery. Number 16, duties of man and wife. Number 17, partition of inheritance. And number 18, gambling and betting. Manu says these are the 18 different types of disputes that come up before court. Today, people who are familiar with courts know that when a civil suit is filed, the person filing the civil suit is called the plaintiff. The claim that he files is called the plaint. The opposite party is called the defendant. The reply filed by the defendant is called the written statement. So we have different terminology developed on the basis of our Anglo-Saxon jurisprudence, which follows the Latin expressions. Now look at this very interesting terminology used by Manu. Manu says, according to Manu, a plaint presented in a civil suit is called Bhasha or Pratigya or Paksha. The plaintiff is called Arthi or Avedaviya or Abhiyokta. Then the defendant was called by Manu as Pratyarthi. Interestingly, Manu says a defendant in a civil suit can set up one of the 4 defenses mentioned by him. What are the 4 defenses? He says, number 1, Sampratipatti or admission of claim. Today in the Civil Procedure Code, you have a particular provision called Order 12 Rule 6. Under Order 12 Rule 6, if a defendant admits the claim of the plaintiff, the court can straightaway pass a judgment without taking any evidence. So Manu says it is possible for a defendant to come to court and say, Sampratipatti, I admit the claim. Second defense, Pratyavasbandhanam, confession and avoidance. This is also called Karanottara. We will not go into all those details. Then he may say Mityokti or complete denial of plaintiff's claim. And number 4, Prajnaya or prior adjudication, which is what is now provided by section 89 CPC. Manu also talks about a principle which is similar to our res judicata today. Today under the Civil Procedure Code, we say that if what is in issue before court in a case today has already been an issue in a previously decided case, then this is barred by the principle called res judicata. Manu has developed something similar to that, and he calls it Vada Sankraman. Manu also talks about joinder of causes of action, misjoinder of causes of action, limitation. He says limitation is what is called bhukti. A stale claim cannot be adjudicated in a court. So our Dharma Shastras have codified lot of such things